to shipwreck the interplay of Admiralty law and bankruptcy law sponsored by both the Florida and New York City chapters of the TMA. My name is Yal Bogan. I'm a Senior Managing Director at Development Specialist Inc. I provide management consulting and financial advisory services in the insolvency space, including Chapter 7, Chapter 11 bankruptcies, assignments for the benefit of creditors, and receiverships. In addition, I provide forensic accounting services, including fraud, contested sub-5 plan feasibility studies, Ponzi schemes, and other matters. I'd like to introduce today's panelists. First off is Brian Moore. Excuse me. Brian is a senior counsel at Togut, Siegel & Siegel, a boutique bankruptcy firm in New York. Brian has represented debtors, creditors, and parties in interest in all aspects of business reorganizations and restructurings. He has negotiated DIP financing, credit facilities, cash collateral stipulation, plans of reorganization, and litigated adversary proceedings. Brian has been recognized as a super lawyer every year since 2016. Next, I'd like to introduce Noah Weingarten. Noah is an associate in Loeb & Loeb, a full-service law firm in New York. While at Loeb & Loeb, Noah has been able to provide practical and sophisticated advice on complex bankruptcy and restructuring matters. Noah has represented debtors, lenders, creditors, landlords, and equity holders, to name a few of his clients. Noah is a member of the Committee of Professional Ethics for the Bar Association for the City of New York. Next up is Michael Moore. Michael is the founding partner of Moore & Company in Coral Gables, Florida. Michael has practiced maritime and aviation law for over 40 years. He has been selected as the Florida Super Lawyer by Law and Politics magazine, as one of the best lawyers in America, and selected as a top lawyer in South Florida by the South Florida Legal Guide and by Florida Trend magazine. Michael has been a director of the Maritime Arbitration Board based in Miami, which is comprised of maritime lawyers and industry executives. Lastly, I'd like to introduce Steve Victor. Steve is a senior managing director at Development Specialist as well, and heads the assignment for the benefit of creditors practice. Steve has provided financial advisory services for nearly over 40 years and works with companies and management, guided them through various distress situations. Steve has assisted companies in various industries, as well as providing financial support to government agencies. I'm happy to have such a distinguished panel with us today. During the next hour, we'll be discussing the interplay of Admiralty law and bankruptcy law. We will hear plenty of real-life stories. Also, for those needing CLE, I will provide the codes during the webinar. Today, we'll start off with an overview of the bankruptcy law, overview of Admiralty law, then we'll compare the two and how they intersect, the process that a distressed company would go through, and with time permitting, we'll hear about recent cases and war stories. Firstly, Brian, could you give us a quick overview of bankruptcy and how it benefits a distressed company?
Sure. Thanks, Yale. Thanks for having us today. So as a general matter, the Bankruptcy Code is, particularly with respect to Chapter 11, is a reorganization statute that allows debtors to have a breathing spell so that they could try to reorganize their affairs. In the maritime situations, a lot of times that'll result in either a reorganization or a sale of its fleet or its assets through a bankruptcy supervised process typically under Bankruptcy Code Section 363. There's also Chapter 7, which is just a straight liquidation provision, which really isn't going to be discussed on today's panel, whereby a trustee would be appointed by the district court and the United States Trustee's Office, and they would supervise the wind down or liquidation of the estate's assets typically in more of a fire sale process. However, for purposes of today, we're mostly going to focus on Chapter 11 and sometimes Chapter 15, which is the supplemental jurisdiction provision of the Bankruptcy Code that allows a United States bankruptcy court to also entertain actions that have been commenced in international proceedings, but allowed to be recognized here in the United States. So those are the two main sections of the Bankruptcy Code that you typically would see involving a maritime or a distressed admiralty type situation. And typically they can be commenced by the debtor itself, by the filing of a petition for relief, or as in some of the war stories we can discuss later, sometimes a petitioning creditor. Typically, it would be somebody with either a maritime lien or a secured financing against a vessel can commence an action either in the bankruptcy court or, as will be discussed, could be also commenced in a district court as part of an admiralty proceeding. But that's generally what the Bankruptcy Code is there to provide an opportunity for reorganizing or other options to restructure and reorganize a company.
Perfect. Thank you. Michael, could you just take us through a similar overview of admiralty law?
Sure. So from the beginning, Article 3, Section 2 of the Constitution has set forth that all matters concerning admiralty and maritime jurisdiction will be tried before what are called Article 3 judges. And I think the primary difference between the conflict, or creating the conflict between admiralty courts and bankruptcy courts, is that one is jurisdictional and the other is a grant of powers. In the case of the Article 3 judge, they're appointed for life, and they have this jurisdiction that's embedded in the United States Constitution. But on the bankruptcy side, it's a grant of power to do things that have to do with regulating the relationship between debtors and creditors. And it's a grant that is, as we all know, for a limited term. It's an appointment, and but if you just kind of read them separately, you can see that it's inherent that there's going to be this classic conflict. I think the biggest thing that's been coming up recently is, you start off in our side of the world when we rarely see lawyers that actually hold themselves out as both maritime and bankruptcy lawyers. I mean, they are in their own worlds. It's a very distinctive practice area. I think bankruptcy was one of the first ever recognized practice areas. Maritime just sort of grew up naturally, but it's been around for centuries, literally. But as these things happen, sometimes the events that really kind of highlight the conflict, I think probably the most famous case is probably because of the woman that was running the Stearns v. Marshall. And this was a woman that was also known by the name Anna Nicole Smith, brought an action, but that resulted in a fantastic case of Supreme Court trying to delving into the conflict between the two worlds. So anyway, I think it's a grant of power and it's a grant of jurisdiction, and inherently, usually through the maritime lien process, you have an issue of insolvency, or it's certainly a creditor a situation not being paid. It's one step away from a bankruptcy filing. So we normally, on the maritime side, get notice of this thing through the suggestion of bankruptcy, and the realization that if you read that law independently, everything is frozen. So now you have the reality of the bankruptcy lawyers versus the admiralty lawyers and how they try to resolve these conflicts.
Great. Thank you very much. We're next going to discuss really how these two laws interplay, how they intersect, and the process and the differences of each. So, Noah, why don't you start us off and talk about the jurisdiction, how the jurisdiction in each of these laws play into helping a distressed company get out of bankruptcy?
Sure, and thanks for having us again, Yale. as most bankruptcy practitioners know, when a company or a person files for bankruptcy, the bankruptcy forms an estate of all of the debtors' legal and equitable ownership, and all of those assets they get tied up into an estate where they are all subject to the automatic stay of bankruptcy. And for non-bankruptcy practitioners here, that means that if you are a creditor of the debtor, you cannot go after the assets of that estate. That's legal. That you can't try to arrest a ship. You cannot try to liquidate necessaries on the ship. You cannot try to continue prosecuting pre-bankruptcy claims against any assets of the debtor. And so that comes from Section 362 of the Bankruptcy Code. The question is, being practical, when you have a maritime vessel, it's easy when it's located, off the East Coast or West Coast, when it's in the territorial waters of the United States. That's the easy case. But being practical, these vessels are not always in the United States. They can be located really anywhere in the world. In Namibia, as we've talked about, they can be located in Puerto Rico, which is a U.S. territory, or it could be located really anywhere. Take the Caymans, take the Pacific island of Vanuatu as another example. And the question then becomes, does that automatic stay still apply to the foreign assets of a debtor? And the answer is typically yes, it does. And so, the issue then is, if you're in a foreign country and you want to do something that affects, a vessel, and you're not quite sure on necessaries, and you're not quite sure that you're going to violate the stay, bankruptcy gives you an option of seeking what's called a comfort order. And that is really an order from the bankruptcy court that confirms whether or not what you're about to do violates the stay or not. And that gives people the comfort that they can take action and not be held in contempt of court. Now, I spoke about about Section 362 as applying in a domestic bankruptcy. Section 362 and the automatic stay, they can also come into effect separately through a Chapter 15 bankruptcy proceeding, which, as Brian mentioned, it's in regular parlance, it's the recognition of a foreign insolvency proceeding. And so imagine a scenario where you have a maritime vessel owner who files bankruptcy in a foreign country, and they have assets in the United States, or they need recognition of that foreign bankruptcy in the United States. In that case, they would the debtor, the foreign debtor, they would file a Chapter 15 petition, and they'd seek recognition of that foreign bankruptcy proceeding. And if they obtain recognition, that is another way that you could potentially get the application of the automatic stay to domestic assets in the United States or U.S. territorial waters. I'm not going to get into the nuts and bolts of Chapter 15, but you could theoretically you could have the automatic stay apply if the debtor's main assets are located here, and if they have assets and businesses, non-transitory businesses abroad, you could also try to get the automatic stay applied there. But the basis is just that, and I'll close out, that the automatic stay is a potential hindrance to creditors to get at access to get at controlling assets of a debtor, like vessels. And there's a way to confirm that you're not violating it.
Great, thank you.
Yeah,
And Brian, you did mention about Chapter 15, that for debtors, for distressed companies that are not in the U.S. And anything that we should know about that, or how it gets into the U.S. courts.
Yeah, so this is Brian speaking. So as Noah touched on, if it's a U.S. based company, it's pretty easy to satisfy the jurisdictional requirements. If it's a foreign based company, which happens often, right? A lot of times, you will have an international shipping company that may be incorporated in Greece, and they may have their ships registered in Namibia or the Cayman Islands or various places. there is oftentimes no ideal one place to be. However, if you have, and typically the way an international shipping company will be organized is there'll be a separate management company, there may be a holding company, and then oftentimes each vessel may be organized in its own special purpose vehicle or its own limited liability company organized under different statutes. So a lot of times, if there is one of those entities that has an nexus to the United States, that would become the lead debtor to then become the jurisdictional hook to bring the rest of those companies in. So, for instance, we had a case where the management company and the shipping accounts for managing the freights was managed here in New York, even though it was a fleet of 47 vessels that were located all over the world in various ports of call, some were even in transit. And in this case that I'm thinking of, one had even been seized by a bank, with a bank that had sought to arrest the ship in a Caribbean island. In that situation, because we had bank accounts in the United States and we were able to satisfy that for that particular entity, its principal place of business in the United States, we were able to bring in the entire enterprise, which was, it was a $1 billion company with 47 vessels that all then came into the bankruptcy court. And later in the case, we then had to get recognition for one of the United Kingdom entities by having the bankruptcy court in the United States be recognized in the United Kingdom for enforcement purposes over in London. So oftentimes you just need to have a hook to get into the United States, even if you're not necessarily dealing with US-based companies.
Thank you. And I think, Michael, one of the things that we discussed was, with bankruptcy, we have the code and very, the rules are there, but there is a practical reality of this when we have a distressed company and when we arrest a vessel, with respect to payroll for the crew and other things like that. Could you discuss that briefly?
Sure. I think that the first I wanted to comment on something Noah said just a moment ago, and then I'd like to get back to Brian for just a moment. I think that and then to your point, but just to kind of highlight the world that we live in. Noah mentioned Vanuatu and maybe a few other flag states. Just to put that in perspective, the Liberian ship registry, which was probably the first so-called open registry, sometimes referred to as a flag of convenience, was in fact created in New York City by a man named Stanley Wright of a law firm called Burlingham Underwood, Wright, White, and Lord. And it was created to compete with the situation in post-World War II America and the world, to create a situation where you could have, U.S. seamen and non-U.S. seamen even traveling on vessels that flew the Liberian flag. But all the other rights of the U.S. Maritime Code would apply. You would not divest this 120-year-old grant that came up out of the Maritime Lien Act. I think the Ship Mortgage Act was 1920. But in addition to Liberia, probably the second one, it was a spinoff of the Liberian Ship Registry, was also created and is based in New York City to once again prove that the world is actually smaller than it first appears. And then, of course, a few years later, I think in the late 70s, early 80s, the Vanuatu flag was created in a place that was the former New Hebrides, but it was also created, the flag state was in New York City. So all three flag states, three of the largest flag states in the world, were based in New York. So it's just a step away from how do we deal with these issues globally as the world continues to get more globalized. And so I wanted to, if I may, Yale, I think that Brian was touching on not only the extra jurisdictional issues that come up in your comparison of laws chart, but the reality of what we're dealing with here in the case he mentioned, which was the vessels that are all over the world, SPEs, SPVs, and et cetera, which is almost universally the structure that you're dealing with. So how does a court, and bankruptcy courts, unlike almost every other court, actually have in rem jurisdiction powers. They actually exert that in rem jurisdictional power. They don't have the power, in my view, yet to execute a maritime a ship mortgage. That's still, as I understand it, still exclusively reserved to the Article 3 judges in the United States Federal District Court system. But I think that the recognition of jurisdictions around the world, you have these decisions coming out of places simply because that's where the vessel got arrested. Somebody that started the ball rolling downhill, and somehow that spirals into, once you do that, of course, every creditor is now piling in. So everyone wants to get paid, and they think the only way they get paid is by piling in. So I thought maybe Brian could elaborate more on the case he referred to, because that to me was like, it sounds a lot like Millennium Carriers. Is that what it's called? The famous massive Millennium Carriers case. Is that the case you're referring to, Brian, or is that a different one?
No, I was referring to the Toysa case, which we filed here in New York, but it was somewhat similar facts in that you had an international shipping enterprise. A vessel had been seized in a Caribbean port of call by Citibank, and we then commenced the case in New York because we had jurisdiction, and we sought the automatic stay came into effect. However, that doesn't necessarily control the Caribbean. So we sought a comfort order in the United States Bankruptcy Court. It was Judge Chapman who issued an order extending the automatic stay. And as part of that, she said that the order not only enforced the automatic stay, but we even were able to negotiate specific language to result in releasing the vessel. Now one of the issues is knowing who your creditor is. And because we had a U.S.-based bank, even though it was an extraterritorial seizure, they have enough of a nexus to the United States that they're going to respect a United States bankruptcy court order. And obviously in that specific situation, we had a U.S. bank, but the same would apply because I think of the 47 vessels, I think we had 14 different banks, maybe one or two had U.S. bases. The rest were international, but they all had some nexus to the United States. And in this international commercial age, a bank based in the Netherlands, for instance, is going to respect the U.S. bankruptcy court. The issue you're going to run into, though, is when you have the lesser priority creditors or the holders of maritime liens, or something you could discuss, Michael, what we call secret liens. A lot of those lien holders aren't necessarily going to have the same nexus to the United States, or frankly care what the United States says, the way an international banking institution will. So what ended up happening in our case is all the vessels were subject to the U.S. court's jurisdiction. The major ship mortgage holders, whether based in the United States or internationally, all wanted to use the U.S. forum to either, result in a true reorganization with a capital contribution or an organized sale. But then as we sold each vessel of ships and each, special purpose entity, which had its own 2 or 3 vessels because they were financed by the same bank, as we went to ultimately market those vessels, we retained an international broker, like I think it was Clarkson's, to run that process, where we would have 363 sales. But as part of those sales, we would have to take care of the necessities in order to clear all the maritime liens, which you typically would not have to deal with in a U.S. bankruptcy case, because that might be considered something akin to a priority claim or a form of a secured claim, but it's its own animal. But in order to sell those vessels, we used the U.S. bankruptcy court forum, where you'd have what we would call a free and clear sale. The sale would take care of the ship mortgage, which is what our international lenders liked. But then in order to put those vessels out to sea to avoid those situations, we would also clear the maritime liens. Now, we were fortunate based on oftentimes, either commodity prices or fuel prices will drive the value of your vessel. But for most of our tankers, we were getting close to 100-cent dollars, so we were able to clear them. And for some of the bulkers, which were more commodity vessels, they actually were selling above par. So in those situations, clearing the maritime liens wasn't an issue, because you still had net equity, which would be put back into the pot in the United States for the benefit of all your unsecured creditors. So that's an example of how the U.S. bankruptcy court system was using some of the maritime concepts to allow for the sale to payment of your maritime liens, but still bringing the net proceeds of the sale back into the U.S. for a global administration with respect to your creditors. Sorry for the long-winded answer, but
No,
that's.
I wanted to,
Yeah.
before we go, if you'll permit me, I just wanted to say two or three things real quick that Brian touched on. And one federal judge said, I thought very succinctly, that when a maritime lien attaches, it attaches like a barnacle to the hull of the vessel and will travel wherever the ship goes. So so anybody that's got a problem there, you need to be attacking the creation of the lien. Whatever country it happened in, that's your first line of attack. I thought that was a beautiful expression to establish that first question, which is, do you have a maritime lien? Even at whatever court you think you're in, you need to have, you're going to prefer to have rather than a general claim, a secured claim or prioritized claim, which is what are called priority liens. And the second part, he says, and the status of that lien, the priority of it, is determined by where these great lawyers manage to get jurisdiction, and that usually, a lot of times, that is New York, because there's a lot of things that give you nexus in New York that you don't get in a lot of other places in this world. And that's where you decide your priority. And I'll just leave on this note rather than continue on the same vein. But I've had federal judges, when I thought I was going to get spanked for forum shopping with the court, said, no, I think that was actually a very good move for his client, because by moving it to the Netherlands, in the Netherlands, it gave the Netherlands Ship Mortgage Bank a superior priority, because that was a smart move. In other words, there is no harm in recognizing that priority will be superior to other lien holders. I'm just saying, for the record, if you have an opportunity to, the captain has not been paid, his crew has not been paid, if you just kind of quietly pay him, a lot of times you'll find that the courts will actually say that was a good move. You got the crew paid, and you're going to get your client paid too.
So I do want to come back to creditors and discuss that. But before I do that, I just want to give the first CLE code to everybody. And it's Marine 2024, MARINE 2024. So Michael, let's talk about the creditors. And one of the things that we've heard, one of the terms we've heard earlier and is on our chart here is the term necessaries. What are these, and how do they get paid?
Well, I think that is, of course, there's a whole bunch of people in the room that have views on that, and I think that I know that in the maritime context there is a well-established regime of maritime liens, and of course that regime changes over the entire world. I mean, almost in every jurisdiction that will be recognized in almost any court. For example, the crew will be paid. The crew liens are just universally recognized as important. But I think that the way you get them paid is almost always through an interim action. The in personam action most of the time is almost useless, because there's simply no real value there. So you're on the hunt for the ship, and you're trying to prove, if you can, that that you have a maritime lien, generally, if not created in the jurisdiction where the vessel lies, but where the priority that's established will be sufficient priority to defeat inferior liens, and also enough equity to pay your clients. And I noticed on your in one of your slides, and just to kind of go back to it, well, we'll get there. I won't go there, but I think the fundamental, the hammer of maritime law, which definitely segues these days, it seems almost universally, with the bankruptcy courts. I'm thinking of a case called Dresdner Bank versus Olympia Voyager, and where in that case we represented the bank, but the ship, there were two ships in two different jurisdictions, and so the question was, how do we get them in U.S. jurisdictions? And we managed to do that. One was arrested in Hawaii, and the other one was arrested in South Florida, and the courts in that case agreed that the two cases should be consolidated into South Florida, even though they would retain jurisdiction in Hawaii, but a lot of these underlying issues would be resolved because there was a bank mortgages, and you're always concerned because you've got 400 or 500 seamen on both ships. I mean, there's 1,000 seamen all total, so there's going to be that they need to get paid, and then where does that money come from? And the answer is, in this case, we had to sell a cruise ship, which was surprisingly not that hard to do, Brian, because you hired Clarkson's. I think they were one of the three that was on our short list. I think it was like Clarkson's, Bill Millard, and Jacques Perot, as I recall. So it's a small world, but we got the ship sold. That was a good thing for a lot of people.
I think that takes us back to the practical versus the legal, and getting the necessary paid, getting the fuel paid, getting the crew paid, making sure that all that stays up to date. Brian, can you compare that to how we pay claims in a bankruptcy matter?
So, Brian, do you want me to go? And then
Yeah, you can take it. No, that's fine.
I mean, in a bankruptcy, you have creditors. Some of them are secure, some of them are unsecured. And, you can try to lift the stay if you're a secure creditor and you try to get paid before the end of the case. I think what's interesting, the intersection here is interesting, is what happens when you have a pre-petition maritime action where you have secured maritime lienors, and then you have a suggestion that you have a maritime ship owner that files for bankruptcy, and you file in the United States, and now you have concurrent jurisdiction between the bankruptcy court, where you have both in rem and in personam jurisdiction, and you have the pre-petition maritime action, where you have all of the other creditors who are trying to get paid out. In a normal bankruptcy, when you file into a Chapter 11, one of the first things you do is you file your first day motions. One of the things you try to do there is you try to pay off all your pre-petition wages to your employees to avoid the feared mass exodus of employees and the inevitable shutdown of the company. And so that's one of the things that that you would see in a bankruptcy is you have your seamen who have been unpaid in my example, and you have your maritime action, which is now half pregnant. It's filed, but it hasn't been resolved, and you now have the bankruptcy filing. And so you go into bankruptcy court day one of the case, say please pay off all of these people, so that they don't leave. And the other issue then is in a maritime action, as Michael was saying, the ship's been arrested. It's arrested in some foreign country in many cases, and so what do? You have the bankruptcy court that has jurisdiction. You've got the maritime court that's liened it up or has arrested it, and so what do you do? Brian, I left on a cliffhanger for you.
Well, the reality is you get into this, the practical versus the legal, right? And the question is, if you try to bootstrap your necessaries and your foreign claims as to how it would fit into the U.S. bankruptcy regime, whether they're secured or whether you treat them as secured. And then one of the questions you'll have to deal with is, bringing them into the U.S. court, and you can always object to the claim and deal with it in that particular forum. And, you have to take a focus as to what are you trying to accomplish in your U.S. case? Are you trying to reorganize, or you're trying to sell? And that might drive the bus as to how you're actually going to try and deal with those situations.
If I may interject, because I think it's instructive. I mean, Casey Flipman, who's on this webinar someplace, I saw her name earlier. We had a case where a fellow in Argentina got hit with a $39 million judgment, and so that judgment got domesticated into a state court in Broward County, Florida. And that gentleman was also the in personam defendant in our maritime case, and he was also the in rem, the ultimate beneficial owner of the in rem defendant, the vessel. So, you're looking at this, and you could write a law school article, and you'd probably conclude, like we're talking about, that one court has jurisdiction over the other, and that maritime law has jurisdiction, exclusively in the federal courts, et cetera. But you look at it and you say, now, what do you think's the chance that gentleman is going to pay that judgment that's being domesticated in the United States of America? And is there any suggestion that he's got the assets to do that? Whereas we have a vessel that we can convert that vessel to real dollars and actually pay off people. What do you think's the better way to go? And so I think that at the end of the day, we simply approach the lawyers up in Broward County, which is the county north of Miami-Dade, where Miami is. There's Broward and Fort Lauderdale. And said, look, we can fight over this thing, and at the end of the day, the lawyers will still be battling it out in wonderful briefs and so forth. But why don't we agree that we'll take the vessel, sell it, and if anything's left over from the creditors, all of whom are secured creditors, because you'll have the custodial fees, and then you'll have the necessary liens, and then you'll have a mortgage lien. But if there's anything left over, and the boat's not that wonderful anyway, it's not a fantastically high value ship, So I simply mention that as a war story, and I'm sorry to get ahead of the war story power curve here, but it just seemed relevant because I think underlying a lot of these comparison of laws, extrajudicial, domestic jurisdiction, and all of these things. I mean, I would never, for example, no matter what the law says, ignore a stay order. I mean, I just wouldn't do it. To me, it'd be like you just want to have trouble. You'll find yourself in front of a bankruptcy judge, and he'll be reading you the Riot Act, and he won't be listening to as you're explaining the niceties of some of these wonderful cases that are out there. Anyway, that's my comment. It's a little bit of a war story.
One question to follow up on that, Michael. Do you find that you would realize better sale proceeds through a sale in the maritime court, or would you prefer it to be in a bankruptcy court, or does it depend if you're using a Clarkson's to broker or to market your vessel either way?
I think first of all, I think that last part is the key. In my judgment, for what this, because there's a huge, obviously the title of this webinar is Maritime versus Bankruptcy. Nothing moves in the global world of shipping, and that's all the way down to yachting and everything up to the largest, super tanker without a broker. They're the people that get up every day and try to find buyers and try to put buyers and sellers together. So yes, we always try to bring in a broker to know about the vessel that's under maritime arrest. How we bring them in, if it's there's a proceeding, you can do it where there's an agreed upon sale. In my judgment, the federal Admiralty courts move pretty quickly. There's a well-established regime of converting seized assets to a marshal sale, I just find, the bankruptcy courts are legendary for moving assets faster than any other court anywhere. It's at a heart-stopping rate. But when you get into the 20, 30, $40 million boats, they sort of slow down a little bit and go, wait a second, what do we have here? So to answer your question, Brian, or comment, Brian, that would be, we always try to bring in a broker in some way. We always try to get maximum value. We think that system is recognized virtually universally, a U.S. Marshal sale is. So therefore, yeah, we're comfortable in the maritime space. We're also comfortable in bankruptcy court. But I think that in the maritime context, you're in a world of maritime players, whether it's sellers or buyers or brokers in the middle, or surveyors or classification societies or P&I clubs. All of that is a global maritime, network, and it's good to have them all involved.
But in the bankruptcy space, you mean, maybe it's worth talking, Michael, for a second about the sale process and the marshal sales.
Mm-hmm.
Because it works differently in the bankruptcy space. I mean, obviously we have the common element of the broker, but is it worth talking for a second about the marshal sale?
Yeah, I think in the Marshall sale, that's one of the problems of the Marshall sale, if it's considered a problem, is that there is no broker as a starting point. It's the United States Marshal. You know, stands in the courthouse steps, reads the court order, may have bids. You know, how does the broker get paid? Well, brokers don't get out of bed in the morning unless they're going to figure out a way to get paid, right? But I think you just make a deal. The lawyers do. The lawyers agree what would be a fair commission for a fast sale, a true auction sale, one that's going to be blessed by the United States District Court. All these advantages. Can we all agree that whatever's put into the court registry, 5.5 or 6% of that goes to the brokers? And I think that's the way we get through that problem, because if you don't do that, no one will show up for the Marshall sale. I mean, there's no broker that's going to call its client and say, oh, I'd like you to have lunch with me today, and we'll take in a Marshall sale while we're doing that. That's not the way it works. They want to know how do they get paid.
That's right. It's not the most robust market either. I mean, these are not that easy to
They're
sell.
very rarefied, small. That's right.
I just want to quickly, before moving on to the next slides, just really talk about the parties and the assets that we have here. You know, I'm used to the bankruptcy. It's very, very clear. You have debtors and creditors. But Michael, tell us about the defendants in the Admiralty when we deal with in persona and in rem defendants.
Right. I mean, what you have you have a regime. I think what you're referring to is how do they, you know, in the bankruptcy context, you have this automatic stay, and you give notice to creditors, and there's rules that govern how you do that. So in the Admiralty context, you start out with the arrest action, which is one of those exceptions to the Constitution. It's a prejudgment writ of attachment, and it's you know, said to be an exigent circumstance, which is why the Constitution grants this prejudgment attachment of somebody else's property. That's why you also have a post-judgment, prompt post-judgment hearing, which is constitutionally guaranteed. And then you have, the question is, how do you bring in, which is your question, how do you bring in these claimants? And the answer is, it's just legal fictions all the way. You know, it's like turtles all the way down. It's like legal fictions on legal fictions. And I think the first thing is, for sure, the owner has notice because their ship just got arrested. So that's assumed. The second thing, though, that you have to do is you have to give notice to all known creditors, or you end up being liable. Your client will end up being liable for those claims. And then, of course, you then have the publication rules. And this is the legal fiction. You basically publish in a paper of general jurisdiction where the asset is located. So, you know, if I'm publishing in South Florida where I sit, you just might not be aware of that publication in New York, in the Southern District of New York, or in Manhattan, or wherever you're sitting. It's just a legal fiction, but the word does get out, and you publish twice, and then through that mechanism, then the claimants come in, and they're usually kind of the same. The category of you know, there may be a salvage claim out there. There may be a crew that's not been paid. Any third-party tort liens, which you immediately start scrambling to find insurance to see if those are covered by insurance. Obviously, the preferred ship mortgages, we have actual notice of that because that's a recorded lien. As you alluded to earlier, Yale, you have the secret liens. Admiralty liens do not have to be recorded to have validity. It's just the nature of the beast. You don't have time necessarily. If you don't know the official number of a vessel, you're going to have a lot of trouble recording a mortgage, a lien, even though you can tell the home port by looking at the transom. You can't get into the registry without an official number. IMO number won't do it. But then you're going to have the usuals, the other ones, the loss of cargo people, the unpaid freight people. But the thing about all of these, including the breach of charter party claims, they're all creditors, and they're all looking to be paid. So they're one step away from bankruptcy the day the action. And the moment you arrest that boat, it's quite often that's the beginning of the end, because everyone piles in, and it's a complete poop show.
Okay. Thank you. I just want to read off the second code for those needing CLE, and that is TMA CLE 25, TMA CLE 25. Okay, so moving on to the next slide, if I can summarize some of the things we've heard, whoops. If I can summarize some of the things we've heard, is that when we have a distressed situation, that most of the time we're starting in the Admiralty court before bankruptcy is even suggested. And this is an ex parte action, and then somebody gets an idea that we should file bankruptcy. And now we have the two courts that are competing over the assets. And from what we discussed, and what I've heard is that basically there are two different groups here. One is the company that filed bankruptcy, and then the other one is the vessel. And it's possible to go ahead and sell the vessel outside of bankruptcy, as Michael said, and then the cash created by that sale goes to pay necessaries and other lien holders, and then that have liens on the vessel and expenses of the vessel, and then any money left over then goes to the bankruptcy court, and that's when the creditors within the bankruptcy get paid through the absolute priority rule. Does that sound about right? Is that what we discussed?
That sounds about right. I think that one of the things that you're leading up to and kind of touching on, which I think it's almost like there's a confluence of bankruptcy and maritime, because we're getting into this, boats move around, so inherently you're international, and you have this situation of boats seized in a foreign jurisdiction. Where are you going to have to resolve the entire the action that's complex? You're not going to do I don't want to put down any particular country, but the reality is the judicial systems in some places are just not as sophisticated, to put this a nice way. And the reality is there's nothing more efficient in the world, if you want efficiency, than the bankruptcy courts of America and the admiralty courts of the district courts of America. I wanted to, as I see we're kind of on a 12:55 timeline here, and I think, does this have a hard stop at 12 o'clock?
1 o'clock Eastern.
1 o'clock. Okay, because I think that what's often the case is that shipyard in Croatia wants to be paid. Now, their remedy, if I'm on the target of what we're talking about here at this point, you have somebody has demanded payment, and they've started a situation that is well beyond the courts of Croatia, which have a limited kind of I don't know what the word would be, but body of law or jurisprudence or whatever, through various government changes or what have you. They just simply don't have the capability. So the reality is you have this kind of meltdown scenario where the boat just kind of sits there rotting away, and hundreds of thousands of dollars, if not millions of dollars, are just kind of evaporate through the passage of time. And when they do finally get to the point where creditors would like to be paid, the boat is sold for nothing and no one gets paid. And making matters worse, as soon as the boat leaves that jurisdiction, it's going to be rearrested someplace else. And so it's just a complete meltdown for just about everybody involved.
I think that's exactly right. And I think that happens more often than not. We don't always have the luxury of being in the United States or having the nexus in the U.S. So that we have these. And most of the contracts on these vessels all over the world have contracts everywhere with different jurisdictions and different venues law that are going to impact a piece of litigation. But I mean, one of these ships pull into, I don't know, Namibia, and there's people on board, and they have to be paid, and they have to be fed, and they most often don't have visas, so they can't get off the vessel. So you have these people who are essentially trapped, and that's why I think a large part of these foreign or ports of call are moving faster than what we might like in our U.S. bankruptcy, or even our ability to go to our U.S. bankruptcy court and go, hey, we have jurisdiction here, but this is in Namibia, and that ship could be sold before that's even filed. I mean,
Yeah, time is your enemy. But
that's right.
you touched on it, Steve. I think you're right about that. We've all read about these cases where people are living on the ships, trying to force the ship owner to pay. But what they don't appreciate is the value of the ship. They're going to run out of food basically because the vessel has no value. It's as someone said earlier in this webinar about there are two things that drive value on ships. I'm talking about ships now, not yachts, and that is cargo and charters. Do you have a use for the vessel that someone's paying for the use of the vessel, or do you have cargo on board the vessel that oftentimes will be vastly more valuable than the ship itself on some of these older vessels? But yeah, it's a doomsday scenario, and I think the people on board just simply don't have the, let's say, or the information to know you're actually not going to have a happy ending. You're going to run out of food.
Or advocates. And even for the owner, I mean, some of that, if it is cargo, it could be perishable. So I mean, your month stay in wherever is the end of that, whatever you're hauling.
I actually
and
have a one
longer, and you miss a whole season. That will create its own
right
domino effect.
I have a 1 minute war story where it goes to your point, Michael, about the timing. We had a maritime case where our main assets we were trying to sell were two vessels in Puerto Rico. And the issue was we were trying to sell them during hurricane season. And we had a knockout blowout fight with purported holders of liens on the ships. And it took, months to fight out the 363F, free and clear aspect of it. And between the time when the judge entered the free and clear order and the closing, the ship sprung a leak below the waterline and started sinking into the Atlantic Ocean.
Just when you thought it was getting, yeah.
And so somebody had the fortitude to get on this sinking ship, the name of our talk here, the shipwreck, and patch the hole. And then, in a real ominous sign of the sale was not meant to go through, there was a hurricane that formed off the coast of Puerto Rico that was supposed to hit right on where our ships were docked. And everybody at that point got on their hands and knees and hoped that hurricane would pass. And sure enough, at the last minute, it took a right turn and it narrowly avoided Puerto Rico. But and then we actually did close the sale, and it was sold in as is where it's condition. But it goes to the point that these are not assets that are located in pristine shape in a warehouse somewhere. They are in the open conditions, and sometimes speed is really of the essence.
All right, so we're just about out of time. So we didn't get all the war stories. Obviously, there's a lot more that we could discuss, and I encourage everybody to look up some of the cases. I hope everybody has learned something about the intersection of bankruptcy and admiralty laws. On behalf of Brian, Noah, Michael, and Steve, and both the Florida and New York City chapters of the TMA, I want to thank everybody for joining us today. Thank you very much.
Thank you all for putting all this together. Take care, everyone.
Thank you.
Thank you.